Good morning, everybody. Thank you for joining us for today's webinar. My name is Amber Hines, and I'm the owner of Ashbur. We specialize in Medicaid compliant annuities as short as 2 months. We offer complimentary planning to all of the law firms and other financial advisors that we work with as far as Medicaid crisis planning goes. My name, again, is Amber Hines, and I'm the owner of Ashbur. I've been working with elder law and estate planning attorneys for the last 15 years on crisis Medicaid planning. And today I'm super excited about having attorney Todd Watley present for us on the topic of irrevocable trusts, because this is something that many attorneys have questions on as to what they are, when to use them. And our February webinar is going to be part 2 of this webinar series, talking about when you would use an irrevocable trust. So if you have any questions during today's webinar, feel free to type those into the questions tab of the GoToWebinar dashboard. And then I also did upload a copy of these slides to the handouts portion if you're interested in getting a copy of the slides from today's webinar. Now I'd like to introduce attorney Todd Watley, who is a certified elder law attorney. He currently practices in Arkansas as well as Oklahoma. And he has a coaching business where he's able to assist other elder law attorneys with frequent questions, common questions that come up, as well as co-counseling with other attorneys. So Todd, I'd like to turn it over to you now, and thank you for being with us today.
All right, thanks, Amber. I appreciate the opportunity, and yeah, this is one of those topics that I love to talk about, and it's super cool. Okay, and so I'm excited. So let's jump in real quick, and I apologize for not being dressed up and looking like an attorney. We got about 4 to 6 inches of snow here, and that's a big deal, and we're not equipped for that, and I wasn't sure I was going to be here or somewhere else, so I'm sorry. I am wearing a ball hat today. But anyway, so what I find interesting with this and working with coaching clients who are just getting into this is what you may see as estate planning. It's like, oh, this person's coming in for estate planning, but they're 65, 70, 80 years old, and they're coming in for estate planning. This can actually be, and probably should be, a Medicaid pre-planning meeting. Okay. And so if you'll start thinking of your older estate planning clients coming in as a Medicaid pre-planning meeting, this is going to open up a lot of doors for you and help them tremendously. Okay. So a big part of that planning is the Irrevocable Asset Protection Trust, the Medicaid Planning Trust. It does a lot, and therefore it should cost a lot. And that's why my title talks about selling the expensive trust. How much should this trust cost? Okay, we'll just jump in real quick. Why do you want to learn this? Why should you learn this? Okay, I think this trust should cost twice what your current revocable living trust should cost. So whatever you're pricing that at, I would double it for this because it provides such a benefit. Or it should cost at least the cost of 1 month worth of nursing home. So I don't know what you're charging for a revocable living trust. If you double that, if you're not to the full 1 month cost of a nursing home, I think you can very easily sell this trust for the full cost of 1 month's worth of nursing home, and that's $7,000, $8,000, $10,000, $12,000. Okay, so hopefully I've got your attention as to this can be a great trust. It provides a great amount of benefit, but you should be charging for it, and it can truly make a difference in your practice if you understand this. Yes, my name is Todd Watley. I am a certified elder law attorney. I've been doing this for 24 years now in February, and that just seems unreal to that. And one thing that I love to do is to teach. I love to, help people understand this, how to incorporate elder law into their practice, and we'll talk about that in toward the end of this. Okay, so what are we going to cover today? We're going to talk about the basics of the Medicaid Asset Protection Trust. Okay, this is an introduction. Next month, I will talk about the exact clients that you should be looking for that this trust fits. Okay, and if you can find the right client with the right fact patterns, where this trust fits their desires and their estate, it's an easy sell, very easy sell. You present it correctly and you can sell this, but you have to sell it to the right person. Okay. I'm going to assume that you know basic trust concepts. I'm going to assume that you've done some trust, you understand how trust works, and I am going to tell you that you will need a trust drafting program to do this. Do not try to draft this trust from scratch. The two programs that I highly recommend is Interactive Legal or Elder Counsel. I know those two do this trust and do it well, and I would highly recommend that you probably have one of those two systems to do this. All right. And I will discuss how this trust differs from the revocable living trust and some of the basic benefits of what this trust does and how it does it. Okay. Let's jump in. So, the secret to proactive planning, working with a client who comes into you saying, I need to do a trust or I need to redo my trust, the solution is if you get them to think further down the line prior to death, but further down the line thinking, what about long-term care? Your client that is 65, 70, 80 years old, they are thinking about that. This is in their mind. They may not bring it up. They may not think you're the person they should bring this up to, but it's your job to let them know, yeah, this is what I do. Not only estate planning, but we also do pre-planning and crisis planning so that if you need a nursing home, we can help you either now or then or both. And the solution doesn't change. To qualify for Medicaid, you have to get rid of assets. You have to be down below $2,000. And if they have assets now and they're not going into the nursing home now, the preferable solution to that is the irrevocable trust, which is the best way to protect the assets that are in that trust. And planning ahead is always better than crisis planning. There's some really cool things we can do crisis planning. That's what Amber can help you with a crisis case, but we can protect more assets for the single person and for the married person if we do pre-planning. If we take these steps now, knowing there's going to be a 5-year look back, that we've got to get through the next 5 years, the solution is the same, but doing it now is way better than doing it in crisis mode. Okay. Your work, you as the attorney, you need to know about these trusts. You need to know these rules, know how this works, know about the trust, and then design the proper, appropriate trust for this person. Now, here's the trick. The challenge is helping the client understand the power of this planning of this trust without overwhelming them. You will find, particularly once you start getting into talking about long-term care, nursing homes, they don't want to talk about that particularly, but they are thinking about it. And so you have to ease into it, and then being able to explain this trust. There's like 3 phases of explaining this. There's letting them know, I do know the issue, I do know what you're concerned about, and I do know the solution, and explaining that to them with enough facts and enough explanation to say, yeah, I can help you, and here's the solution, versus that sweet spot of saying, yep, please do this for me, I want to hire you. But you can go past that to the 3rd phase of overwhelming them. If you go into too many facts, if you get too much into the weeds of the taxes and different things like that, they will get overwhelmed. And typically they're just like, no, too much, I don't care, I need to go home, or I don't want to do that. So there is a point in working with coaching clients over the years, I have seen that it is very easy that once you learn these rules, once you learn what this can do and how it can help people, you tend to go overboard. You say too much, you go way into the weeds, and these people, rather than saying, okay, sure, do it, even though I don't understand it, they'll just say, oh my God, no, I can't do this. So you've got to be careful to give them enough information to say, yes, I know your problem. Yes, I know the solution, versus going way too far and overwhelming them. So that's the challenge. And I will tell you how to do that today. Okay. Why this matters. Planning early, families, both single and married, can save more of their estates when the time for care comes. Okay. This trust will save a large portion of their assets, get them in a much better position to qualify for Medicaid later on, as opposed to not doing this trust and then doing crisis planning or not being able to do crisis planning. If someone has $3 million, crisis planning is probably not going to work, because with the annuity, you can only stretch it out for so long during their lifetime. And if they're 85 plus, their lifetime's not that long, and it just becomes difficult to deal with big estates. So putting a portion of their assets into this trust gets them in a better position, so that after 5 years with a smaller estate, we can now do something with that. We can get them on Medicaid, protecting everything that is in this trust. Okay, so let's look at a situation. Let's talk about Grant. Okay, Grant comes in and he wants to see you for estate planning. He mentions that he has a revocable trust that probably needs some changes. Grant is 70 years old, still plays tennis 3 times a week, i.e., is pretty healthy. Okay, he's not going into the nursing home this week or next week, or probably within the next 5 years. He's in pretty good shape. He has a girlfriend that he's been seeing for the last 2 years, but has no plans to marry. Okay. Grant lost his wife 5 years ago to cancer, so therefore his estate plan may not exactly do what he wants, and so he comes in to you to address that. Grant has a home worth 675 and total liquid assets of about 550. Okay. I wouldn't call this guy poor. He's not rich, but this would be a difficult case to do single crisis planning with this much of a house and that much in assets. He wants to revise his current trust to provide for his girlfriend some money and then leave everything else to his children. Grant has income of $4,500 a month. He's able to live off that, pays all of his bills without having to dip into his $550,000 worth of assets. So therefore, his income's fine. This money is just sitting out there, just hanging out. Okay. So we have a solution for Grant at the age of 70. A conversation about long-term care and how is he going to pay for it is appropriate. And I think this is one thing that sometimes attorneys getting into elder law have a difficult time with, is bringing up that topic, because sometimes people don't know that you're the person who can help them with it. They're thinking insurance, or they're just thinking, I'll deal with it when the time comes. There's really not much I can do right now. This is your opportunity to introduce them to say, yeah, I can help you with this. As an elder law attorney, this is what I do. This is one of the things I can help clients with, both crisis when you're going into the nursing home, but since you're 70, since you play tennis and you're healthy, let's talk about some things we can do to get you in a better position for Medicaid once the time comes. And some people say, nope, don't want to talk about it. Okay, fine. You brought it up, you gave them the opportunity, but I will tell you, a lot of people will be like, yeah, that is in my mind. I do think about it, but I didn't know you were the person to bring this up with. Yeah, I'm that person. Okay. So he may be a great candidate for long-term care insurance. Okay. That at 70, with this much money, needing care, he possibly could afford it, and it may be something he wants to talk about. And that's where you go back to Amber and talk to her about it. Okay. But we know we can design an irrevocable trust that will hold part of his 550, since he doesn't need most of that to live each month. He doesn't need it. So some of that can go into the trust, but definitely his $675,000 home would go into this trust and be protected. This will also give him peace of mind that no matter what happens with his the assets in this trust will be protected. And that's very appealing to people. And particularly once you get, I use these numbers as about the minimum, and I'll talk about that next month as in who this is appropriate for. If you're under about $500,000 in liquid assets, this trust is not appropriate. But this gets really appealing once that 550 is a million, 2 million, $3 million, and they're living off their income. They don't need this money. It becomes very appealing to them to say, look, with $3 million, I may never be able to get you on Medicaid. But with this trust, if you'll put some of that $3 million into this trust, you will be in a much better position 5 years from now to now qualify. And so that's where we're headed. Okay. But how do we explain this to Grant so that he will hire us and pay the fee for this trust, this very beneficial trust? How do you get him from coming in to your office thinking he's just going to update his revocable living trust to now paying you $10,000 to do this new trust? Okay, that's where you need to understand what's going on and how to explain it to the client. So in the initial meeting, you're going to explain the concept of the irrevocable trust. You will explain to them how Medicaid works, how Medicaid says you've got to be under $2,000 before you can qualify, gifting rules, penalties, things like that. You need to understand Medicaid before you can explain this, but then explain to them, sitting as you are, 5, 6, 10 years from now, when you need nursing home care, I can get you qualified, but it's going to be difficult, and we're going to lose about half of all of your assets. So if you don't want to lose half of your $1 million+ we need to do something now. I suggest getting the client comfortable with the idea of asset protection first, just the general idea of saying, yes, there is something that we can do now, and we can do something with these assets to protect them. Get them on board first, and then get them to and say, yes, I can fix this problem for X number of dollars. Get them to hire you, and then jump into the trust discussion. Okay. Sometimes depending on the client, sometimes I will lay out the trust first and then hope they hire me. But sometimes you just sell the idea of, yes, we can do something. We'll figure out what that is once you hire me. One thing that will surprise you, and people call me all the time, coaching clients will call and say, Todd, I presented this great case and they didn't hire me. I was like, that's fine. Okay. Understand, this is a big step. Taking $3 million, if you're dealing with a $3 million case, they've worked very hard their entire life to build this $3 million. And the idea of you coming in saying, okay, you need to lose control and benefit of it, is very traumatic. They're like, oh my goodness, I came in here not thinking this, and you're telling me that once I do this, I will not be in control, nor will I benefit from a whole lot of my money. That's a shock to their system. They're going to need some time. But I will tell you in just a second how you present this to them so that it's very appealing to them to say, and it's appealing to them eventually. They're going to go home and sleep on this for a few nights and think, man, I don't like losing control of two million of my $3 million, or 2.5 million of my $3 million. But if it's protected and I don't have to worry about it, and I know absolutely that it's going to go to my kids if I do this trust. But if I don't do the trust, I'll pay $10,000 a month for nursing home basically for the rest of my life. They will think about it. They will sleep on it. I've had clients come back 6 weeks later, 6 months later, and 2 years later. Sometimes it takes a while, but they'll call and say, hey, Todd, didn't like what you presented when you first gave it to me, but I thought about it, and I want to come in and let's do that. Okay. So don't be depressed if they, and I almost will not let them make this decision in the first meeting. Okay. Yes, that means another meeting, but the last thing you want is for someone to say, oh yeah, this sounds great, let's do it. You get to work on it, and then they do the opposite. They get home and think, wait, losing control and losing benefit, that scares me. I don't want to do this. This is too quick. And they call you and say, I don't want to do it. And it's like, well, I've already worked on the case. I've already done it. Do we refund? Do we? So I would definitely rather them not hire me in that first meeting, even if they're all on board. Yes, I want to do this. Say, okay, but you need to think about this. This is a big change. This is a big change in your financial situation. I want you to go home and think about it. Let's schedule an appointment in 2 weeks. You think about it, talk about it. You're going to probably have some questions. Come back in 2 weeks. Let's sit down. And many times, if they were gung ho then, they'll be gung ho then, but they've thought about it and you can justify, okay, I'm going to get to work on this. I'm going to earn this $10,000 fee pretty quick. So if you change your mind, it's going to be different. And, I'm going to keep a lot of that. And so they understand that. And it's just better to be safe and have them wait rather than let them hire you in this first meeting. That's just a practice point. You don't have to do that. But having done this numerous times, I would prefer them not to hire me the first meeting. So, as you're explaining this, some attorneys use buckets as the analogy for the trust, piggy bank. I like a briefcase, and particularly with the irrevocable trust, with the briefcase, you can either keep the briefcase open so that you can get to it. That's the revocable trust. With this irrevocable trust, it's a lockable briefcase. You shut it, you lock it, and you give the key to someone else. You don't control it, and you don't benefit from it. Okay. All right. So what are we trying to achieve with this trust? How is it so nice? How does this trust do what we need it to do? Okay. Number one, we're removing the assets from the reach of a possible Medicaid applicant and their spouse. Okay. So this is where it comes in really nice. If you've done Medicaid planning, you understand with the spouse, we can protect probably upwards of $1 million. The problem with spousal crisis planning is we've switched all the assets from being both spouses or one or the others only to the one spouse. That's great to get this person on Medicaid very quickly. And that's what a lot of married people want is we've got to get him care immediately. Yes, we can do this, but we've transferred all the assets to the community spouse. Once the community spouse needs nursing home care, now we've got this big lump of money and it becomes very difficult to get that person now qualified. And I think that's what Congress was thinking, was giving us these very generous rules for a married crisis case to say, sure, we'll pay for his care, but we know in what you've done to get him qualified, you've given all the money to her. And now when she needs nursing home care, we're not going to have to pay that bill. Okay. The government, she's going to have to pay. So it becomes difficult to get her qualified with a large amount of money. This trust fixes that. It gets both of them broke. So the money's gone for both of them. When he needs care now, after 5 years, we've got a little bit of money. Sure, we can get him qualified. She gets to keep a little bit to survive. But then when she needs nursing home care, boom, done. Okay. Everything in the trust is protected. And so this is a great case for the single person, obviously, to get them down below $2,000, but it's also good for spouses to get both of them qualified. And the trust provides protection to the assets as opposed to the outright gift. And so families may say, well, it sure sounds like I'm just giving away these assets into this trust. Why don't I just give it to the kids? Well, we'll talk about that in just a second. And I will give you some pointers to say, well, we could, yeah, effectively for Medicaid purposes, we are just giving this away. But with the trust, we get to protect some tax benefits. And I'm going to go through that with you. So, just like I said, we take advantage of tax breaks available with these trusts that you don't have available with outright gifts to the kids and protections. Okay. So, the primary tax related goals that we're doing here is we are wanting to achieve a step up in basis of the trust assets at the death of the grantor. This within itself can save tens, if not hundreds of thousands of dollars. I do a radio show every Wednesday morning. I just did it this morning. This morning, a guy called in and the topic was this. I had this on my mind. And so on the radio show this morning, I was talking about step up in bases and trust and different things. And this guy called in and said, Todd, I wish we had hired you, because when my parents died, my four siblings and I, um, this case was messed up. Dad gave us the property prior to his death. The attorney recommended that he give us the property prior to his death. Each of the four kids had to pay $125,000 in capital gains tax because they did not get a step up in basis. This trust would have fixed that. So there, if you, and I'll talk about this more next month, but a really, really good fact pattern for this trust is they own land that they've had for quite some time, and it has increased in value tremendously. And so therefore there's a basis issue, and doing the trust so that we get a step up in basis can save hundreds of thousands of dollars, and you're only charging $10,000 for this. Okay. So that gets into your sales pitch to say, look, here's the benefit of this trust. I'm saving you a step up in basis worth X number of dollars, and I'm only charging you this much for this trust. We also get income and capital gains from this trust can be taxed at the grantor's individual tax rates, which are typically lower than the kids. Okay, not always, but when you set this trust up correctly, one of the tax benefits is the income and the capital gains from the trust can be taxed at the grantor's individual tax rate. We will also preserve the real estate tax exemptions. If your client's over 65, typically there are some tax advantages, homestead, freezing of taxes. Once a person hits 65 and giving the property to the kids, they will lose all those benefits. But in this trust, when it's worded correctly, you will still get to benefit from those county or state tax exemptions for older people owning real estate. And you also will preserve the IRS 121 capital gains exclusion. So when it sells, you can get that $250,000 per owner exclusion still, even though it's owned by the trust. Okay, so those are some pretty substantial tax benefits that you want to get from this trust. So to do that, to get those benefits, we have to show the IRS that the applicant, the grantor, still owns these assets, still has some strings attached to the assets so that we can get those benefits. So we're technically showing that the assets are still in the estate of the applicant and it doesn't transfer until the person's death. Okay, that's how we get these tax benefits, is showing that it doesn't transfer fully until the person's death. Now, for Medicaid, okay, the primary Medicaid related goals is to say, hey, Medicaid, it's gone. We did this more than 5 years ago. We put it into this trust that says under the Medicaid rules that they don't own it anymore. It's gone. It's transferred. We can't get it back. We don't control it. We don't benefit from it. And so from a Medicaid standpoint, we're saying we don't own it. It's gone. So the conundrum, okay, let's say. So the conundrum is when you go through this, and in this meeting, you're educating your client to say, okay, you've come into me with $1 million plus. You wanted me to amend your trust to take care of the girlfriend and the kids or whatever. But here's the bigger issue is long-term care. Whatever the cost of care is in your state, you've got to make them aware of that and concerned about that and think about it and want a solution for it. So as I'm going through this, I do just what I told you. You look at their facts and say, oh, you have this land that you paid $500 an acre for, and now it's worth $20,000 an acre. That's a basis issue. And for the IRS, for you to still be able to get this to your kids at the current fair market value, and they sell it and they pay zero tax, you need to hang on to this property until you die. All right. To get some of those, to maintain the tax benefits of not going up each year since you are now 65, the 121 exclusion, all of that, you've got to hang on to this land. So for IRS purposes, to get those tax benefits, you need to hang on to it. However, for Medicaid, once you get sick and you need nursing home care, Medicaid's going to see that you own all of this land over here, and they're like, hey, that's over $2,000, so you're disqualified. So therefore, if you want these tax benefits to get on Medicaid, you can't get on Medicaid. You're going to have to pay $10,000, $12,000 a month for the nursing home. Okay. But we get these tax benefits. So if you're concerned about $10,000, $12,000, $15,000 a month for the nursing home, then we need to get rid of these assets, which means your kids are going to lose the eventual tax benefits. You're not going to have your homestead exemption. So which one do we choose? Which one's best? And you present both of those to say, this branch of the government says, hang on to it until you die. This branch of the government says you need to get rid of it and not benefit from it for us to benefit you here. Which one do they choose? Ta-da! We don't have to choose. The solution is this trust, the Medicaid Asset Protection Trust. Now, technically, this is known as an intentionally defective grantor trust, okay? Do not use that word. Do not use that name in the meeting. Your client doesn't need to know the technical name of this trust. People don't like to buy defective products, okay? And you can explain all day. It's really not defective. We're doing it, but just don't go there, okay? Don't use the name. Just say the solution is this Medicaid Asset Protection Trust. And they're like, well, how does that work? Well, the solution is for the IRS, we can say, yep, you still own it. And for Medicaid, we can say, nope, you don't own it. And that's a very fine line, and it takes intricate wording and knowledge of the rules to be able to tell one branch of the government you own it and tell the other branch of the government you don't own it. Okay. And that's where they're like, wow, that's really cool. I get both of the benefits. How much are you charging? And you say, I'm only charging whatever you're charging. Okay. Because it is definitely worth the benefit, and it will sell if you sell it to the right person. Now, how do we do this technically? Okay, this is the weeds that you really don't want to get into this with the client. This is just something you need to know how this trust works, what Interactive Legal and Elder Counsel is doing in this trust, why they're asking you certain questions, and why you should answer certain questions certain ways is how we get this. Okay. Do not, from this point forward, I would not mention this to the client unless they're a tax attorney or whatever. Okay. Clients don't care about this. They just want the solution. So the grantor needs to be treated as the owner of the income, interest, dividends, rents, and the principal interest in the trust for tax purposes. Okay. So we need some language in there that says they still benefit from this trust for the IRS. The result is the income and capital gains is taxed at the grantor's lower tax rates. Now, I don't want to get too far into the weeds because I'm sure there's going to be questions after this, and I want to quit early. But I personally, in my state, the Arkansas DHS office has said, if your client receives the income from this trust, we're going to say this is a countable asset. Even though that completely violates federal law, it violates the terms of the trust, it violates everything. Just them saying, here's our initial stance, it takes us 2 years to fight it. I don't want to do that. I don't want to be the guinea pig that tries to get this through the court system. So when I'm selling this, the grantor does not receive the income. Okay. I think there are other ways to still get the IRS benefits without getting the income. I want the income to go to the beneficiaries. Yes, it's going to be a higher tax, but they will pull the income from the trust and put it on their personal tax return as opposed to leaving it in the trust. And I'll talk about that in just a second. But from my standpoint, I don't let the grantor get the income. You, in your state, you possibly could, and I would research that to see what your DHS office is doing and not making your life difficult like they do in Arkansas. But personally, I don't let my client get the income. Okay. So the married, this is the income tax issue. You don't want to leave the income in the trust regardless. It needs to go somewhere each year. I send it to the beneficiaries, but you could theoretically give it back to the grantor. The reason being you don't want to leave it in the trust is you can make upwards of $578,000 for a married person before you get to the 37%. Okay. You don't pay 37% until you get up to the 578. But if you leave it in the trust, the irrevocable trust income, if you leave it in the trust, once that trust income hits 14,450, it's at 37%. So a lot of times a trust is going to make way more than that, and you're paying 37% for anything over 14,450. Whereas giving it to the individual, unless they're making tons of money, 578 a year, they're not going to be at the top tax rate. So therefore, pull the money from the trust, give it to themselves. They will then pay the income tax. Again, this is something you explain to them after you've done it. Okay. And we can pick and choose who the income goes to or whatever, but I don't want them to stress about this when they miss the big picture of step up in basis, $10,000 a month nursing home bill being paid. Don't let them focus just on the taxes. I typically bring this up afterwards. Now, we need to have grantor status of the trust. So there's two ways we can do that. You need one of these two powers mentioned in the trust, and your software will do that for you. Number one is the power to substitute assets of equivalent value. And number two is the power to add charitable beneficiaries. So as you're going through your software, you will get these options. You definitely need to do one of these two, if not both of those, okay, to have the power to do that. And what's interesting is it can be held by the grantor, trust protector, someone who is not involved in the trust, but the power does not need to be exercised, only held. Okay. So you just got to put it in the trust and have that option there so that the IRS will look at it and say, you still have the grantor still has enough power to do something so that we don't fully know who the beneficiary is until the date of your death. And so therefore the IRS says that's enough of a string that we're going to bring it back into your estate, which is the defective part of this. You typically would do this to get things out of the estate, but you messed up, quote, by including one of these powers. So therefore the IRS says, gotcha. We're going to keep this in your estate, which is exactly what we want so we can get the step up in basis. Okay. But for Medicaid purposes, those two powers doesn't mean that our grantor gets to use the asset. They just get to decide where it goes. So under the Medicaid rules, this is not enough power to make it a countable asset. It's still not coming back to them. They just get to decide it goes here or there or whatever, but it's not coming back to them. How to achieve a step up in basis. So if the grantor maintains some level of control over the trust assets at their death, that provides a string that will pull the assets back into their estate for estate tax purposes, providing the heirs a step up in basis for the trust assets. Okay. Now, specifically, and you'll do both of these things. One is to just make it a grantor trust. The other is to achieve a step up in basis. You'll use one of these, a limited to certain appointees, not the grant. Sorry, you will use a limited testamentary power of appointment. Okay. Now, this will be limited to certain appointees, not the grantor or the grantor's estate or creditor. So, yes, it is a power of appointment of the grantor can still say where things are going. Okay. But it just can't come back to them or to their estate or to their creditors. Okay. And this gives the grantor the ability to leave something in writing saying she is changing who the death beneficiaries are. Again, the IRS says, oh, we don't know who the final beneficiaries are because this person still has the power to change that. So number one, that's good so that we get a step up in basis. Number two, this can save your bacon, and not that you're in trouble for this, but I had a situation one time where I did this trust for a lady who had, I think, $2 or $3 million. She was leaving it to 3 children. At that point, all 3 children were up, fine, fully employed. Everything was great. She calls me about 2 years later and says, "Hey, Todd, my one of my sons was in a bad car wreck, is brain damaged, and will be in a nursing home the rest of their life. And he's out of money. He's on Medicaid. And what about this trust? It's irrevocable, but it's leaving a third of my $3 million estate to this child." And I was like, oh no, this is bad. This is terrible. And so I'd forgotten about this, had not been doing this very long. I go back and I'm reading this saying, aha, we can change where the money goes to. So I drafted a will for her to say, she is going to exercise this power of appointment and basically disinherit that child and split it between the 2 other kids. Problem solved from a practical standpoint, being able to do what this lady wanted, but also from a tax standpoint, this gives us a step up in basis. Okay. Again, this provides enough of a string to pull it back into the grantor's taxable estate, but still for Medicaid purposes, she's not giving it to herself. She can't give it to herself. So therefore, for Medicaid, it's like, yep, it's gone. All right. You want to make sure the grantor can still reside in the home. That's probably the one thing that people will get nervous about. It's like, I love my house. I want to live in my house. I don't want anyone to kick me out of my house. You're like, fine, this trust will address that. The trust will give you the right to live in your home because under the Medicaid rules, the right to live in a home is a non-countable resource. Okay. You can own your home outright, but you can definitely live in it and it not be a problem. So the trust can say, and probably should say, yes, the person can live in their home. No one can kick them out. They get to right to live there. Now, in some states, if your state has expanded estate recovery, meaning they look at things not just before death, but after death, no, expanded means they don't look at things after death. They look at things just before death and they count everything that you own prior to your death. In Arkansas, we don't have expanded estate recovery, so they look at the things 1 second after death. If you have expanded state recovery, they're going to look at things 1 second prior to death. If you have what would equate to a life estate interest in this house through this trust, that could be brought into the estate by Medicaid and a lien put on it. So therefore, the recommendation there is not to create a life estate interest, but just the right to occupy. Okay, the right to occupy this house will not mess up Medicaid, but will give them some assurance that they can still live in this house and not get kicked out. Okay. All right. There is obviously more to this. Number one, I have not gone into the exact fact patterns that you need to be looking for. This doesn't sell to anyone. If someone comes in with a $100,000 house and $50,000 in their bank account, this trust isn't for them. Okay. You don't have enough money to get through the 5-year look back. It's just not for them. So there are certain cases where this works. And when you can know which cases it works for, it's beautiful. They will hire you. They will gladly pay pretty much whatever you quote them on this and be glad that you brought it up to them. Okay. So Amber, I am through. So next month we will go into how to sell it, who to sell it to, more of those things about exactly how you can get this sold to people and um, enjoy the benefits of it.
Awesome. Thank you, Todd. We do have a couple of questions here. The first question is, do you also do the Medicaid application or promise to do a Medicaid application when the time comes, as far as doing pre-planning and then if the case transitions into a crisis Medicaid case?
Okay. No, I do not. I tell them, hey, this will not get you qualified. There's still going to be some work later on. Come back and see me, and they will see you as the expert. They're like, hey, this guy really understood this, brought this to my attention, and solved my problem. And so you want them to come back and see you, but it's going to be at least 5 years until they can actually qualify for Medicaid, particularly if you put $1 million+ in this trust. I mean, that's a 5 year look back in just about any state. So it's going to be 5 years until they can really apply for Medicaid. But I do tell people, hey, we're hoping nothing's going to happen for the next 5 years. We're pretty sure. I mean, to do this trust, we need to have some assurance that you're not going to need nursing home care within the next 5 years. But if you do, hey, come back and see me. We can work through these numbers. Possibly, I mean, probably the only thing you're going to do is, hey, we didn't put all of your money in this trust for this very reason, to help get you through the 5 years. So you're just going to have to pay for the next 5 years. On the 61st month, come back and see me. Let's see where you are asset wise, and we can get you qualified. Then it's going to be another contract and another round of work, and I'll be glad to do that for you. And I am ultimately trained to do that. But this fee, this 10,000 or whatever fee for this, is just for the trust and getting it funded and the deeds and all of that stuff, powers of attorney, different things. But yes, I can do it later on if you choose to come back and see me, but that's a whole nother round of work, whole nother fee. And they'll probably ask what you charge. And I would be honest with them. It's like, well, at that point, today I charge X number of dollars, give a range. I don't know what I'll charge 5 years from now, but today, if you need crisis Medicaid work, personally, I charge between 7,500 and typically not more than 15,000. So somewhere in that range, depending on assets, how much work there is to do. But yeah, I'll be glad to do it for you, and I can do it, but this fee does not cover future work.
Okay, and then there's a follow-up question here about that same topic. Does this trust help if you're within the 5-year look-back period?
Oh. Yes, particularly if you have large amounts of assets. So I typically say the best client is the one that's not going into the nursing home for 5 years. But just imagine if someone comes into you with $3 million, chances are they will never qualify. They will never spend all of that money for the nursing home. But you can give them some assurance to say, look, in 5 years, we can stop the bleeding of you paying $10,000 or $15,000 per month for the nursing home. This trust will stop the bleeding in 5 years, but I can't stop the bleeding for the next 5 years. But with $3 million, they've got enough money. Just run the numbers to say, okay, their income is this. Their income's $3,000 a month. The nursing home is $8,000 a month. So therefore, we need $5,000 a month, plus a little bit with inflation and stuff. So $5,000 a month for the next 60 months is $300,000. Probably ought to set aside about $350. So with $3 million, keep out $350, put everything else, $2,650,000 into this trust. And then 5 years from now, you should be out of money. And we can now apply for Medicaid on the 61st month, as opposed to doing nothing without doing this trust, never being able to qualify. So it typically is for the client that does not need nursing home care, you're pretty sure, for the next 5 years. But it can be for the client that has lots of money and you just want to stop the bleeding after 5 years.
Okay, and who is a suitable trustee for an irrevocable trust?
Okay. So one of the weeds I did not get into is, what if you need money from this trust? And one of the ways you can give your clients some um, comfort to say, okay, what if we miscalculate? You don't put everything into the trust, and I'll cover this next month, but you don't put everything into the trust. You keep out, like I said, God forbid, worst case scenario, what if we need nursing home care in 2 months? We've got to get through the remainder of these 5 years. So you really do want to keep enough money out to help get through that. But if for some reason we burn through that money and the person is truly broke and now we need some money from this trust will create what is known as lifetime beneficiaries. You want that to be the kids. It could be one kid or it could be all the kids. And you want the trustees to typically be the kids. So they now control it. And if needed, they can pull money from this trust and give it to themselves as a lifetime beneficiary. And then, as I explain this, and I use these exact words, the kid, out of the goodness of their heart, can now give money back to the parents. You cannot put any language in this trust saying, if the parent needs money from this trust, the kids can pull it and give it to them. That absolutely annihilates the purpose of the trust, and it will not be protected from Medicaid because you've shown that the grantor can get money from this trust. So the wording is the grantor absolutely cannot get money from the trust directly, but we have lifetime beneficiaries so that the lifetime beneficiary can receive money from the trustee, which is typically going to be another child or that child themselves. So they're the trustee and the lifetime beneficiary. Mom calls and says, look, my car died. I need $20,000 to buy a new car. Kid says, okay, fine. They pull $20,000 out of the trust, give it to themselves. And then they, out of the goodness of their heart, give the money to the parent to go buy a car, or the kid just buys a car. So you don't want commercial trustees typically because they won't go through that process for you. You typically want trusted children. And if there are no trusted children, maybe a sibling or someone out there who can be the trustee of the trust. But you definitely need lifetime beneficiaries during the lifetime of the grantor. The lifetime beneficiary can pull money from the trust, give it to themselves, and then if they choose so, they can then give money back to the grantor.
Okay, perfect. And then we have a question here about clients don't like to lose control of their assets. With $2 million, they can easily self-fund assisted living or nursing home care. In addition, they'll be on Medicaid versus private pay. So the purpose with a large amount of money of the asset protection trust is that the kids are benefiting with a lesser care for the parent. How do you address these types of issues?
Love that question. So in a lot of states, and I practice in 2 states, just like Amber said, I practice in Arkansas and Oklahoma. In Arkansas, every nursing home takes Medicaid. So people have that mindset. I don't want to go on Medicaid because I don't want to go into a nasty Medicaid nursing home. In Arkansas, that is absolutely not the case. In Oklahoma, not every nursing home takes Medicaid, but there's some really nice, very decent, good care nursing homes that do take Medicaid. And once you're in that nursing home, the staff, the care that you get from the staff cannot be any different. They don't know who's paying the bill, nor do they care. So getting on Medicaid is not the stigma in most states. I don't know your state. I do know Arkansas and Oklahoma. I don't know your state, but I can almost guarantee you there are some really decent and sometimes really good nursing homes who do take Medicaid, and your level of care should not differ between Medicaid paying the bill or you paying the bill. And if your client is just absolutely dead set, I would rather pay my money to the nursing home. Sure, this trust doesn't work for them. But there's a lot of people that once you explain to them, there's some decent nursing homes that do take Medicaid. And in Arkansas, every nursing home takes Medicaid. You're not sacrificing your care by taking steps to follow the rules, the federal rules, going through everything the federal law requires us to do, which is mainly the 5 years of we're not going to pay for your care for the next 5 years because you transferred assets into this trust. Once you go through that and suffer that penalty, then the government will pay. A lot of people want to do that. They're like, hey, if I can do it and it's legal and I'll get the same care, sure, let's do it. And so that's one of those objections. People don't like to lose control. And that's why I said you won't sell this many times in the first meeting. You explain to them, sure, you're going to lose control, but everything's protected for your children. And they'll think through that and finally get over the stigma of not being in control versus what they've worked for their entire life now benefiting their children. Most times they'll pick benefiting their children.
Okay, we have a situation here that somebody laid out. It says family is husband and wife, no kids, no grandkids. The intent is to leave to charity, total assets of around $4 million. Is this a good trust for them?
Sure. I mean, yeah, to know that. Now you got to be careful, because then who's going to be the trustee? Who's going to be the lifetime beneficiary? I would be very careful to keep out of the trust absolutely enough money to pay for care for both of them, which I don't know what your nursing homes cost. I don't know what their income is. Um, and just keep out enough money so that they feel comfortable, and that if they do need nursing home care within the next 5 years, they can pay for it, because chances are they're not going to be able to get any money from the trust with no kids, no lifetime beneficiaries that would then benefit them. But I would still throw it to them to say, yeah, we can guarantee that 2 million of your $4 million will go to charity. Let's create this trust, make the charities the beneficiary, maybe make, commercial trustee or even one of the charities the trustee of the trust, so that you don't have all of those fees or whatever. But yeah, yes, you can make that work, but just keep out enough money so that absolutely they can get through 5 years worth of nursing home care. But because otherwise, if you don't, it's going to be problems if they both need nursing home care and you've not gotten through that 5 years.
Okay, and then somebody had a question about the two software platforms that you mentioned for drafting. I responded to them directly, but I also wanted to let you answer that as well.
Yeah, I've used both. I've used Elder Council, which does a great job. I currently use Interactive Legal. There's pros and cons to each. But just pick one of those two, because those are the two that I trust to do this. They have the brain trust behind the software to do this correctly and make sure that it works. So those are and I'm not saying there's no other software out there that will do it. I just know those two will do it correctly.
Okay, and then under the limited power of appointment, can a grantor leave property to their descendants?
Sure. Yeah, that's the whole purpose of it. Yeah.
Okay. There's a couple other pretty specific questions here that I'll get to you afterwards, since we're running out of time here.
I can just email you.
Okay, perfect. And then I want to thank everybody for joining us today and invite you all back for the February webinar, where Todd talked about what he's going to be discussing in February, when to use this trust and when it makes sense. So with that, thank you, everybody. Thank you, Todd. That was great information. We have a lot of questions here, so I will get those over to you. And thank you. Take care, everybody.
Okay.